which are basically like primary legislation of the Knesset, of the parliament. This emergency regulation can be in force up to 3 months. And then if parliament extends it, it becomes regular legislation, or it has to be approved after 3 months or discredited by parliament. So this is the second meaning of declaration of emergency. So on paper, it's a very enlightened arrangement. There is checks and balances of parliament. Parliament declares emergency. Parliament can approve emergency regulation. And if it doesn't approve it, it's being voided after 3 months. And one can also add to this that the courts first of all, emergency regulation cannot violate human dignity. So they are also bound by some of the constraints of normality. And the courts review both emergency regulation and even the declaration of emergency. Okay? And this dates back to the 60s, where courts said even emergency regulation can be reviewed by us if they are proportional, if they are the regulations are justified, and so forth, so on. Okay, it's not the same level of scrutiny as regular measures of government, but the courts are willing to interfere, and the courts are even interfering in the existence of emergency itself. Okay, having said all this, okay, in practice, Israel declared emergency in 1948, okay, and this declaration of emergency was extended by the parliament since then every year consecutively. So we are in a basically permanent situation of emergency legally. And now one can say you have justification, we had a war every 3 years, we had so forth, so on, but this is of course total abuse of what was thought to be a temporary, very, very limited measure. In 1999, the Association of Civil Rights in Israel approached the Supreme Court and challenging this extension of declaration of emergency. And the court was quite responsive. It didn't order to terminate emergency, but it said that the government should prepare for the termination of emergency. One of the consequences was that a lot of emergency regulation, including the anti-terror legislation, was enacted as regular legislation, and this is in preparation for the termination of emergency. So what we see here, and I think that this is quite an universal or important lesson generally, that one of the problems, and I think that we see it also in other countries, one of the problems of emergency constitution model is that once you terminate emergency, you actually adopt the substantive arrangement to normality, and this all negates the whole idea of emergency constitution.
Okay. Saying business as usual for the Israeli case, and we know that there is no written constitution. Do you mean that when different entities act according to business as usual, the one who has not a written constitution will have more flexibility and more maybe also opportunity to modifications?
Not really, not really.
It doesn't affect.
Well, for practical purposes, we have a constitution. Why? Because the court is willing to review legislation as violating human rights, violating basic law liberty, freedom and liberty, which contains the basic human rights. And since there is constitutional review, it's basically like any other constitutional regime, with the only difference that basically the Knesset can actually overturn the decision of the court by regular law, and this almost doesn't happen. Never happened, basically.
In 1994, but
yeah. And this is something that is very interesting for us Israelis, because on the political level, on the rhetorical level, you know, this right-wing government attacks the court as a very liberal institution that puts hurdles in our fight against terrorism and so forth and so on. And but it never, this is screaming or political expression that were never manifested in actually reversing the decision of the court. So it's a very interesting play between politics and law, but this is something for a different lecture.
So 5 minutes?
5 minutes, okay. So the main counterterrorism law, first of all, as I said, what we have is an inheritance, British inheritance, and this is quite interesting because the defense emergency regulation that were enacted in 39 were a model that exists in many ex-British colonies. You have very similar regulation in Cyprus, you have very similar regulation in India, you have actually very similar regulation in Britain itself, in Northern Ireland. And this emergency regulation included a penal code, very severe penal code, as well as administrative measures, extensive administrative measures. Some of them were abolished in Israel itself. But what is important here to say that these regulations also are in force in the occupied territories. Why? Because like Israel that actually inherited the British law, Jordan and Egypt, who controlled the West Bank and Gaza respectively, inherited British law. And when Israel became the occupier, this was the legal situation there. But one has to say that it's a little bit different than the situation in Israel, because in Israel itself, some of the regulations were abolished, a thing that we cannot do in the occupied territories, because the law of occupation does not allow us to change the laws there. Okay? So, for example, there is no more deportation in Israel proper. This was abolished by the Knesset. It was a power that was granted by British emergency regulation. It exists in the occupied territories. The same with house demolition. Administrative detention. The provision in the regulations were abolished in Israel proper, replaced by the administrative detention law from 1979 in the occupied territories. It's the original British legislation. Okay? So this defense emergency regulation, as I said, include a very harsh penal code with military courts judging the perpetrators or the accused, and also administrative measures, detention, house demolition, deportation, restraint on people, and various other issues. And again, what made those draconic powers less draconic is the review of courts of their actual use, and I will give 2 examples in a second. The second arm is the Prevention of Terrorism Ordinance from 49 that is now abolished, replaced by the new Counterterrorism Law, which also included, it was a piece of legislation that was enacted 5 days after this assassination of the UN envoy by a Jewish underground, and it was utilized only against Jewish terrorism until the 80s, when this ordinance came out of the drawers in order to try to confront the rising Palestinian terrorism, and also some kind of Israeli, the left-wing Israelis meeting with the Palestinian representative of the PLO in order to try to strike a deal. But this was replaced together with the finance of terrorism that was enacted in 2005. This was replaced in the Counterterrorism Law, and I will say a few words about this new piece of legislation. Okay? So the new piece of legislation, the main disadvantage is that it's a regular legislation. It's not anymore emergency legislation, it's business as usual. The good side of the legislation is that although it contains a lot of draconic powers, it is much, much less harsh than the counterterrorism law and some of the British regulation that it replaced or repeals. Okay? What is quite interesting in this regard is, I think this relates to Barbara's topic, the definition in this counterterrorism law of act of terrorism and terror organization. These are the two very important issues. Okay, what is an act of terror? Okay, and what is a terror organization? Why? Because if we relate to an act of terror different from a regular criminal offense, this means various protective issues that a usual criminal enjoys, a suspected terrorist might not enjoy. Okay? And one can see that the definition, I will not get into it, every piece of this law merits a whole symposium, but basically the definition of act of terrorism is act of terror is quite enlightened one. Act of terror is basically, first of all, a crime defined by a penal code. Okay, it cannot be something that is not criminal activity otherwise. It becomes act of terror because of the motivation, which, as you can see, is a religious, ethnic, ideological motivation with the intention to cause fear among the population. And these various elements of the definition, which is very extensive in the law, safeguards the misuse of the definition of act of terrorism. It cannot be used just as against political objectors, opposition, and so forth and so on. So this is one thing that is very important and is a step towards a more progressive legal arrangement.
Sorry, could I maybe just ask one small question?
Sure.
Because you're in this detail, that does it actually reflect any distinction principle? Does it actually say it needs to be directed at the civilian? Does it? I can't read, to be honest, because I can read some of the main outlines, but I do.
It doesn't have to be directed against civilians. It can be also, terror can be also against uniform, but it is, in a sense, if it's regular fighting of regular army, it's not an offense. It has to be an offense. So it has to be either murder or another offense. There is no offense which is separated or independent from the penal code. It has to be basically a crime according to the penal code. What makes it the act of terror is a special motivation, which we usually don't require with regard to regular crimes. What was motivating you to do the murder or to do the attempt murder? the motivation is ideological, political, religion, and initiating fear in the population. Okay, so this is, I think, an important component of the definition of an act of terror.
Yeah. I guess she has a good point. I mean, apart from this distinction principle, which is only applicable during armed conflict, but let's assume that there is a soldier and he kills out someone, which constitutes an offense in an ordinary sense. Then he would be by default a terrorist under all circumstances because he's representing his armed forces. So when he's representing an idea of nationalism, an idea of ideological, whatever. So whenever there is a prosecution for a soldier for killing a man beyond his official duty, he ends up as a terrorist.
Not exactly. If he goes and kill Palestinians just for the fun of it, or not for the fun of it, for ideological reason, he's a terrorist, and he will be.
That's what I'm saying.
Yeah, but if it's in a fighting, in a concept of belligerencies, in a concept of an operation, he's doing his duty. So the motivation, whether he got an order within a campaign or within the regular activity of the army, he will not be regarded as terrorist. If he all of a sudden thinks I should now kill Palestinians around and shoots Palestinians, and motivation is ideological, then he's a terrorist. And by the way, we had, of course, examples of soldiers or people in uniform, in duty, committing act of terrorism and being sentenced, being as terrorists. In a second. A very, very important issue is so complicated is the organizational element. Okay? That you have a very elaborate infrastructure of an organization that supports, funds terror organization. And again, I think I will not delve into all these slides I can make available. One cannot misuse the law in order to declare opposition organization as terror organization, okay? Because what you have here is an organization that is using illegal activities, violence, and so forth and so on, and also supporting organizations. But what is very important here is the process in which terror organization is declared. Or an organization to be a terror organization. A recommendation from the head of the General Secret Service has to come to the Attorney General, who is a very independent position in Israel constellation. It's not a political position. The Attorney General recommends the Minister of Defense or committee of members. The organization is issued a warning and can appeal, okay? And the appeal is heard by a special tribunal headed by a retired Supreme Court justice. Mm-hmm. So again, all these safeguards make sure that the definition of terror organization will not be applied to just an opposition or an organization that politically is not favored by the government.
That is, by the way, one of the two ways to declare a terrorist organization.
The court can also find.
The other one is Security Council resolution automatically being adopted by the Israeli cabinet without that process.
Mm-hmm. Okay, under 1267.
Yeah, but this organization can also appeal to the tribunal. Yeah, an international organization that is declared by the United Nations becomes a terror organization in Israel, but if this terror organization go to the appeal process, it can challenge this as well. Okay? It's not
easily, but it can.
Yeah, not easily, but even there is a safeguard of misabuse on the international level of this definition of terror organization. Okay? What is here also important is that we have some new offenses that are connected to the organizational elements of terror organization, in addition to the regular penal code, which means membership, heading, supporting, and other activity within the organization, even if you don't conduct terror activities. Okay? And membership on the organization, heading the organization, assistant to the organization is a criminal offense itself. And what is important here is that the support for terror offense, prosecution according to this offense, have to go through the Attorney General approval as a safeguard of freedom of speech. Okay? And this is very important. It's not that any prosecutor can just bring to justice a person who supports a terror organization. Again, it's an important safeguard of misuse of terrorism, definition of terrorism. But the harsh part of the counterterrorism law, that once something is classified as terror activity, okay, the penal code, the penal process, or the criminal process is a little bit less protective of the criminal or the accused rights, in the sense that there is a process of privileged evidence, what may be the most significant discount in the regular criminal process. And now there is the Israeli Democracy Institute initiates maybe an amendment to the law according to which there will be some kind of a third party looking at the privileged evidence. Okay? So this is the most significant change in the criminal procedure. By the way, there is no more military courts according to this law. It's regular courts that will judge, adjudicate the accused terrorist or allegedly terrorist.
So now conviction might be based on privileged evidence? I mean,
yeah.
So this is a major change in the criminal procedure in Israel.
With regard to terrorism, not any crime. This existed already according to the regulation, the British regulation and the ordinance as well. Okay? What does it mean, privilege? When there are sources of information that for security, national security reasons cannot be revealed to the accused, the court can basically assess them without the accused or his attorney present. Now, in a sense, this is a judicial creation. This is one of the interesting examples in which the court actually created the arrangement that was afterward entrenched in the law itself. Okay? It began in the 50s and 60s. There is in the evidence law a situation in which the state can declare immunity or privilege on certain information, and this information will not be revealed to the other side. This is already many years ago. Now, basically, the default situation was that the court used this evidence without scrutinizing. And then the court, this was in the 50s and 60s, said, we'll you whether this is justified, and we will review the evidence as an inquisitorial system. Okay, and this was a practice that was not entrenched in law, and this finally got into the counterterrorism law as a permanent arrangement. Okay? So this is the harsher thing. What also we have is, detention before judge order is extended to 72 hours before instead of the regular 24 hours. But these are minor changes of the regular criminal procedure. Okay? What still remains very draconic is various administrative measures that are empowered by the law. Forfeiture of property connected to terror organization and various other administrative measures which are adjudicated by administrative court or can be challenged in administrative court. Again, very important. Everything is reviewed by the courts. Okay, and these measures, and empowered by the counterterrorism law, replace most of the measures, much more draconian measures that were prescribed in the British mandatory emergency regulation.
Can I ask you a question?
Yeah. 3
3
minutes.
I should not.
No, go ahead.
On the failure to inform, so if that's a crime, like what's the threshold? Because I'm thinking of, for example, journalists sort of embedding with organizations, just wanting to know their causes, things like that, or on the other end, even scholars. Like what's the threshold for failing to inform? Is it failing to inform that, you know, of someone being a member in a terrorist organization, failing to inform of specific plans to commit an attack, failing to inform of sources of income, organizational structure? What does it refer to?
No, it's failing to inform about a terrorist attack that is planned. Okay. And actually, this belongs basically in the criminal law, the regular criminal law, a failure to inform the authorities of a crime, not misdemeanor, not a parking offense, but a crime that is 3 years, which means 3 years and more, is an offense independently from terrorism context. And there is, you know, this doesn't exist in the US, for example. Okay, if you know that I'm going to kill someone, okay, not terrorist, I want to kill my wife because she betrays me, okay. And you fail to inform the authorities, you breach the law. Okay? So in this context, failing to inform about terrorist attack is not really extra draconian measure. In the US, you don't have this offense. Even if you know that somebody is going to kill and you don't inform the authorities, it's not an offense. I think in Germany it is an offense. It is an offense.
But is membership in a terrorist organization considered as like a severe enough offense for it to constitute a crime not to report membership in a terrorist organization?
No, I said only terror activity itself, terror acts that are going to be committed.
A bit under like general Israeli criminal law. What's the sort of, how serious does a crime have to be in order for it not to be reported to be considered a crime itself?
Crime that entails 3 years in prison or more. Mm-hmm. We have 3 categories. Misdemeanor, felony, and crime. So only failure to report a crime, which means basically violence or maybe burglary even. I don't know, armed burglary. Or I don't know exactly what is the threshold of 3 years, but severe crimes.
I have just a quick question about the forfeiture of property.
Yeah.
Is that similar to freezing assets for a specific period of time, or does this mean confiscation of property for good?
Confiscation for good. Can be confiscation for good, yeah. Last word, sorry that I took a little bit more time, is the role of the courts. As I said, this is very, very instrumental, and I will give you 2 examples. We'll skip that. With regard to the administrative measures, okay? The court from very, very early on, from 1941, ruled that everything is justiciable in regard to administrative measures that are taken against suspected terrorists. In the beginning, it was very, very formal procedural review, but in the last 40 years, it includes actually substantive review. And this is a major decision from 1981, Baranza decision, in which a Palestinian who was ordered to stay in his hometown, restriction order, because of suspect of terrorist activities, challenged this in court. The court said this measure, struck down and said this measure, all the administrative measures, which is a very important precedent, are legitimate only as preventive and not as punitive measure. You have the criminal part as punitive measure. And in this sense, the state did not have met the burden of proof to say that this person has a future danger. And this precedent became very, very controversial in 30 years, almost 20 years later, in 1997, when the Supreme Court ordered to free Lebanese Hezbollah soldiers, Hezbollah militants, who were kept by Israel as bargaining chip for the Hezbollah actually captured an Israeli navigator and basically later transferred him to Iran, where his steps were disappeared, and the Israeli forces held some militants from the Hezbollah as bargaining chips. And the court said this is not a preventive measure. There is no legitimation to hold people as bargaining chip. You have to release them, and the government abided. And this was a source for a legislation, again, showing the dynamics of court decision prompting legislation that is contingent on emergency regulation, unlawful combatants law, which actually gives the power to, actually defines what is unlawful combatants and specify the powers or the measures that can be taken against them. Another example of the very, very instrumental intervention of the court is house demolition. Okay? House demolition was used as an immediate response to terror attacks. It began in the 60s, in 1967. There were a lot of house demolition after the Six-Day War, but as a kind of punitive measure, it was used since the 80s, while the Supreme Court held that a person whose house being demolished has the right to apply to court, and the demolition cannot take place until the court gives its ruling. And it became much less effective. And in 2004, the army itself recommended to not to use this measure because of the legal hurdles. And here the court really, the intervention of the court for many years made this measure unusable at all. Our new right-wing government in 2015, following the knife attacks, started to use the house demolition again. And in the Supreme Court in the last 2 years, there are very, very alarming voices saying that we might declare this measure as unconstitutional altogether, not checking its usage in specific cases, okay? Which again brought to a decline in the actual usage of it. And this shows how the court is very instrumental in curtailing the powers of government. And the last there is also very interesting decision of the court with regard to incitement and freedom of speech, which also chilled down this support in terror organization offense. And the last example is interrogation techniques. There was a practice of our General Secret Service, again based on British practices in Northern Ireland, on interrogation techniques which used some quite draconic or methods like loud music 24 hours. It was not torture in the sense of pulling nails out or electric shocks, but it was very loud music, tying a person to a chair in a very uncomfortable position, and various other techniques that the British actually developed. And this was challenged in first there was a commission, a state commission chaired by a former president of the Supreme Court who said torture is illegal, but if one can show a necessity defense in criminal law, okay, if somebody knows where the bomb is and the bomb is going to explode in 10 minutes, and the only way to discover where is the bomb is to torture someone, okay, this can constitute a necessity defense in criminal law, okay, and if one can show a necessity defense in criminal law, then we can legitimize this action. This was challenged in the Supreme Court, and the Supreme Court in 1999 gave a decision saying torture or physical pressure or whatever is illegal, period, in any circumstances. Okay, very, very categorical decision, and whether this decision is followed or to what degree is followed is something that I don't know. Probably it's not fully adhered to, but again, this shows the importance of the voice of the court in the actual law in action or counterterrorism law in action. Okay? One can summarize by quoting Aharon Barak, our former president of the Israeli Supreme Court, saying that what distinguishes democracy from a non-democracy is that fighting terrorism cannot use any measure, and a democracy fights with one of its hands tied behind its back. And the maxim here, he refers to the American and some European approach, the maxim that during war the legal institutions are silent, attributed to Cicero, is not justified and not right, and this is not the Israeli jurisprudence. And I think this captures instead of a more structured conclusion, this captures the Israeli approach to counterterrorism law. Sorry for taking more time, but I thought that, yeah, but I thought it would be good to have kind of a general introduction. So thanks very much.
Thank you. So let's take